I've done my homework now on Michael Strickland. I
Mhm.
know you want to talk about it, and it's a good segue into the Rittenhouse, and it's a good framing of where we are now in general. If I'll summarize the facts as best as I think I understand them, and then you'll point out mistakes if I made them.
Sure.
Michael Strickland is an independent journalist. 2016, he's covering a protest. It's not BLM. I forget the name of the group. He is, even by the Court of Appeals judgment, aggressively confronted by a number of protesters. Being aggressively confronted when he's trying to leave, and people recognize that he was trying to leave, he draws a firearm. There's video footage of it all over the place, left, right, and center. Doesn't seem that he ever had a finger on the trigger. Had the gun pointed down, displayed it to frighten the people, which it did, but not entirely. Reholsters it or puts it back. And then people are saying, let him go, let him go. Even after that incident, two people are sort of shouldering him and not letting him go, but he gets out. Gets tackled by SWAT or police a short while later, arrested, felony charges for brandishing a firearm, among other things. He's found guilty of 10 charges of felony brandishing a firearm, even though only 2 witnesses showed up for the trial or testified during the trial. Confirmed on appeal, or was it not confirmed? There was something that went to appeal, which was admissibility of evidence as to his prior experience having been assaulted and having his arm broken, which, it was going to be used in theory to provide evidence to his frame of mind for why he drew the weapon. Is that close enough to all the material facts?
Yeah, I mean, really, there was a few other facts, some that are pertinent for taking it up to the U.S. Supreme Court, some that would be pertinent to a habeas petition. But what happened at the trial level was, one, they lied about him. The prosecutor did leading up to the trial. There were a lot of false statements about him. They accused him of racism and a whole bunch of other things. Basically, if you want a script for how Rittenhouse is likely to be treated, and for all of these charges we've seen, including the St. Louis couple and other places, it all started in Portland, Oregon, in the prosecution of Michael Strickland. The weaponization of the prosecutorial offices to punish people who try to defend themselves began in the Michael Strickland case in Portland several years ago. And they just simply have been replicating it in all of these other cases across the country where someone has asserted any level of self-defense. They have been targeted. That's why what happened to the St. Louis couple was not a surprise if you were familiar with Michael Strickland's case. I think it's Laughing at Libs is both his YouTube page and his Twitter feed. You can find all the details about it. He's a grassroots journalist, a little guy, not physically big in stature. He had previously been assaulted by groups for filming them and exposing them. And this particular group had said they were going to target him. Antifa types and the same type of people that have been looting now over 100 nights consecutively in Portland. There was even video footage the police was aware of them getting together that day to assault him. The groups were anywhere between 5 and 10 people at different junctures. And they spotted him filming their public event. He's had, of course, a public right to do so, a right to free press to do so. And they kept approaching him throughout the day, basically telling him to get out. And then they were marching right towards him to assault him. And I think even the Court of Appeals opinion admits that one person, I think they call it pushing or something of that nature. But it's interesting the language they use when it's along those lines, when it's the politics is on the other side. And all he does, and between getting assaulted in that day, he had trained himself in self-defense in a proper manner. So he had a right to have the gun. He knew how to use it. He said, if you fear you're going to be assaulted again, you show it, you back away from them, show them the weapon, and then put it away. And he does exactly what his training taught him to do. And what expert witnesses would have testified to. He was denied certain evidence. A whole bunch of evidentiary issues happened at trial, which we'll get to. So the core is you have a little guy who's got a history of being assaulted by this kind of group, this group has a history of assaulting people like him in Portland. All he does is brandish a gun briefly while he's walking backwards and puts it down, maybe just seconds, it's shown, and then walks away. And then but instead of none of them get arrested, typical Portland, instead he gets arrested. and he gets charged with a bunch of felony crimes of brandishing a weapon and so forth, of having a dangerous weapon and exhibiting it in a particular manner, etc. He hires a local lawyer. The local lawyer knows some good Second Amendment cases and self-defense cases, but is really not familiar with these kind of political cases. And so early on, they discover that the jury pool is very biased. And rather than move to transfer the case out of Portland and do a different jury trial, the trial lawyer recommends not doing a jury trial and having a bench trial. Well, there was no chance that that judge was going to give him a fair shake, but it was naivete on the part of his counsel. And even though the judge is handling the trial themselves, so the judge is going to see all the evidence anyway, whether it's formally admitted or not, they're using the case to try to set a precedent. And so they deny him a bunch of evidence throughout the proceedings that are essential to his defense.
Let me stop you with one question. Who's representing him? Is it a state appointed, or is it his own counsel?
His own counsel. People raised money, kind of like what's happening currently with Rittenhouse. People raised money for his defense. But unlike Rittenhouse, they actually did hire someone that was familiar with Oregon criminal justice, familiar with self-defense law. So the lawyer for him was much more qualified than either John Pierce or Lynn Wood would be for Rittenhouse, but still made certain mistakes because they weren't familiar with how political cases work, didn't quite anticipate the politicized nature of the case in certain ways, so hadn't prepared in advance. And the big mistake was having a bench trial take place. But what's amazing is usually with a bench trial, the court just lets all the evidence in, so there's no argument about excluding evidence that matters. The fact that the court went out of its way to exclude evidence that was exculpatory meant they were trying to use the case to set a precedent so they could basically deny the self-defense defense to other people in the future in Oregon and could be cited in other contexts across the country. I was retained after the conviction to try to do an appeal and help with sentencing recommendations. He ended up getting time served effectively. I think he did 120 days in jail, if I recall correctly. They put limits initially on his ability to do his job. Some of that was restructured over time, and he got probation beyond that. And so we were able to help on that side. But the main goal was to establish a full self-defense. The key piece of evidence that were excluded was, one, the history of these groups of people, the violent history of these groups of people, including the violent criminal history of the individuals involved. Second, what happened in terms of his past history of him being assaulted under these contexts and circumstances within the recent past, which is why he reacted the way he did. And third, statements he made to the police officers at the time of his arrest, which were exculpatory and went to his state of mind. Notably, as usual, as we'll get to later with the Court of Appeals in the Covington case, the Court of Appeals for Oregon pretends that two of those three issues are not before them and only addresses one of the three. Now, it's at least an implicit admission that our arguments were right on those issues, but instead they focus solely on whether or not you have to consider the subjective history of the participants in evaluating self-defense. Yeah. So and this has gone back and forth across the country, but to give people an idea, objective reasonableness was never meant to remove subjective circumstance or state of mind from self-defense. And that's a major miscue and mistake that lawyers have made and courts have made at different times over our history. Because what the goal is, like Wisconsin law is clear on this, but all law should be clear on this, in my view, consistent to both the Second Amendment right of self-defense, which goes beyond the right to bear arms, in my view. The U.S. Supreme Court in Heller said it's a right of self-defense. I see the right of self-defense thus as constitutionally anchored and rooted in terms of how statute should be interpreted. And then secondly, the Fifth Amendment right, that there has to be subjective intent, subjective mens rea, in the old Latin phrase, the legal terminology, before you can convict anyone of a felony. And when you do a pure objective test, you completely ignore the defendant. And what really ends up happening is judges end up substituting their personal political judgment for the reality of what took place. They start saying, well, if I had been there, I would have never done that. And that must mean it's unreasonable for him to have done it.
So actually, I'll stop you there just because there's three things we should get clear. The evidence that was not considered, the evidence that was dismissed, one was the violent pasts of the, let's call them the aggressors, or the the protesters, whoever they were, whatever you want to call them. So their violent history was not considered or was not admitted as evidence, which, some people are going to understand because the proof of character might be, they're not even the ones who are defendants. Okay, that's one element. The second element that was not, that was refused as evidence was his history of having been tackled by that other guy a while back, broke his arm in 3 places, was on disability, was traumatized, if not, had some sort of lingering psychological trauma from it, which made him, more susceptible to fear for his own safety, or at the very least more precautious to protect himself. What was the third thing?
And the third was his statements to the police officer that were exculpatory that explained that. Okay. So basically what they did is they said nothing subjective matters. So like, for example, it would be like if Tim Pool was assaulted at an Antifa rally, Tim Pool couldn't talk about his own history, couldn't talk about Antifa, and let's say he tried to defend himself at some point, that he couldn't talk about any of that because it's not whether Tim Pool would have exercised self-defense, it's whether the judge would have. Yeah.
So here's the thing. Actually, Real Mbambuga says 10 counts of brandishing a weapon. How many guns did he have? We're going to get to that as well. One gun, and it was one incident that lasted 3 to 5 seconds from what I saw. Mm-hmm. So here's the thing, and I was thinking about this over the weekend. The criteria is reasonable fear for your safety of an objective person, whoever that abstract objective person is. I understand the argument to consider the subjective element of that individual. But then the flip side is you get into this situation where an Amber Geiger type situation where you have what might be subjectively, reasonable in her own head, but is so objectively unreasonable. You get into the situation where if you admit of that defense in, let's just say Amber Geiger's case, and you apply it to Michael Strickland, you get into the situation where someone might have subjectively justified opinions to themselves, which are so objectively unreasonable based on their own, whatever the reason, mm-hmm. that it shouldn't be a defense to what they did.
Yeah, and the key there is the language of the law is that what does the defendant, what the jury's being asked, what does the defendant reasonably believe? They're effectively substituting that so that if a defendant believes something and you have no doubt they really believed it, that isn't enough. The defendant's belief has to be reasonable, but it's still about the defendant's belief. They're basically scratching that. And they're saying, would a reasonable person have done what the defendant did? Not what did the defendant believe and why did the defendant believe it? And then whether the defendant's belief was reasonable. And so the net effect of that is it's going to ultimately over time impose the judge's own personal definition of what's okay to do and not do. There are a person's own personal, like when we were talking about Rittenhouse, we were like, well, we wouldn't go there, where we wouldn't have our loved one go there. This is creating a scenario where they can say, well, you know what? Rittenhouse never should have been there. So I'm going to say no self-defense. And I'm going to ignore entirely what was going through Rittenhouse's head. What was Rittenhouse's life experience? What was Rittenhouse's understanding? The other reason they're doing this is they want to exclude the evidence of the history of violence by Antifa. So not only, he had a personal history of people just like this attacking and assaulting him and threatening to assault him. They want to, so he had the extraordinarily strong evidence on this Accords that they excluded from the trial and for no particular purpose. Remember, the judge is handling the trial. So they're doing this solely to create a precedent. So in the future, you will be evaluated by whether or not the judge feels that the judge would have been there in the first place, whether the judge would have had a gun in the first place, whether the judge ever thinks it's okay to brandish a weapon in the first place. That's what's they're going to superimpose their own values.
Well, so that, this was my thinking, reading this over and listening to it on the weekend, is his personal history became not a red herring, but something of a distraction, because even by the Court of Appeal's own rationale, I could even set aside his personal history and say he might have been overly fearful, and set that aside. They're going by the objective standard when the Court of Appeal in their own language says he is being aggressively pursued or pursued aggressively by protesters. I think they themselves have eliminated the subjective matter. I don't see how they get around it. He's being pursued aggressively by protesters. He's entitled to carry a concealed weapon, permit in law. And yet it was criminally sanctionable of him to draw the weapon when being pursued aggressively by protesters. I don't see, even as a matter of fact, an assessment of the fact, setting aside his personal history, how they get to that point.
Oh, no, I mean, I agree. I mean, what they're really saying is that they're not going to allow people to exercise self-defense because they don't think you should. Because they think, what would a reasonable person do? They're going to substitute their own judgment. A reasonable person wouldn't have a gun. A reasonable person would never brandish a gun.
Well,
That's
or
effectively.
they're going to say if Strickland is so traumatized that he's so fearful that he should just avoid those situations and not put himself in a situation where he might overreact to what an objective, reasonable person would not overreact to. But even by their own description in the Court of Appeal decision, they acknowledged he was being aggressively pursued. So, and I guess taking it in abstractum, I don't know what incidents had occurred at the time this went to trial in 2016, but we see what happens when people get aggressively pursued now on multiple occasions. What's the status of the appeal now? Or like, what's the status of the file in terms of appealing the underlying decision itself?
Well, so we asked the Oregon Supreme Court to take it. They chose not to. So now our only option is the U.S. Supreme Court, which is always a long shot, of course. These days, they take 999 out of 1,000 petitions that get filed with the U.S. Supreme Court get turned down. And they may see this as a state law issue, but to me, it's a constitutional question, the scope of self-defense and whether the state law can be interpreted in this way. And because it has broader consequence for everybody. So in my view, they've got to, for example, in the criminal tax context, where I've done a lot of work, for a long time, they started reinterpreting objective. There's something called willfulness. You can't have committed a tax crime unless you were willful in what you did. And the court recognizes the complexity of tax law. It makes it easy to basically prosecute anybody, anywhere, anytime. And so they said, in order for you have to actually know that tax law prohibits your action for that. And unlike self-defense, its objective unreasonableness is only a factor to consider in terms of whether someone believed it, but it's supposed to be purely a subjective reasonableness test. And yet what courts were doing were effectively issuing directed verdicts and imposing an objective reasonableness requirement. And the whole reason objective reasonableness is there is for what you were talking about. Someone who has a crazy belief that what they're doing is in self-defense, you have no doubt they believe it, but you also have no doubt that they had no reason to believe it. It's not supposed, but what happens is judges easily, who don't like self-defense as a defense, gut it by saying, no, it's a purely objective test, and that's going to end up being their own personal judgment. And ultimately, it's going to gut the ability of self-defense, especially here, where we all know what the circumstances are now. If you studied it back then, you would have known it then too, if you'd been a Tim Pool type. But we all knew that that kid had every reason to realize, Michael Strickland, if he doesn't pull his gun, he may get beaten, he may get killed. But from the sort of naive, the evidence that proves that, all excluded. He's not allowed to present any of that. He's not to say, look, people just like this have assaulted me before. Okay, they've made threats. And
stop there. I mean, now in Canadian civil law, if evidence is not permitted, there's you have a right of appeal right away, without going to the trial, without going to a judgment, which will have an impact that can't be undone. Did he appeal that refusal of evidence at the time, or did he wait until the judgment had already been rendered?
In America, you have to wait until judgment's rendered.
Okay, and I want to make sure that I'm 99% certain. Dismissing the admissibility of evidence is appealable of right in Quebec civil law. This is now when we say a bench judge, a bench trial means it's a judge. There's no jury that has to appreciate the evidence or the admissibility. The judge does both.
Correct.
And the judge does not consider the evidence, renders the judgment. It goes to the Court of Appeal. Court of Appeal, from what I read, it was a 6 or 7 page judgment, says his past experience, that's a neoplasm, his experience it was irrelevant to the test. Nonetheless, and I think they can still get around it. Okay, fine. It was not relevant, but nonetheless, he was being aggressively pursued, and it was not a reasonable response for protection. How do you appeal that to the Supreme Court when it's going to be based on the assessment of the trial judge and the consideration of the appeals judges?
It violates the Second and Fifth Amendment rights because it basically negates mens rea under the Fifth Amendment because it basically says that his state of mind is irrelevant to a defense that's all about a state of mind. Because and that's, while they don't say that about the issues they didn't rule on, that's the ramification by what they did rule on. Because what they said is it's purely an objective test. which most courts have rejected that. Most courts have recognized it's not a purely objective test. First Oregon court to say it in that way, period. And so it's deeply problematic. By the way, by contrast, they actually cite the case. They use that objective test measurement as a way to protect people who weren't really defending themselves, who had notice and knowledge of other facts to protect actual criminals from prosecution when they were shooting at police and other people. So it's so political in Oregon, the court system there, and it's very dangerous what they're doing, because if what they're doing is upheld, self-defense does not have the meaning that it has always had in American law, and in my view is protected under the Second Amendment. So the argument to the U.S. Supreme Court is twofold. Question presented number one: does the Second Amendment require subjective circumstances of a defendant to be considered when evaluating the reasonableness of their conduct under a self-defense privilege assertion? And secondly, does the removal of a subjective intent violate their due process rights under the Fifth Amendment, under the Winship Doctrine that the Supreme Court has established, which basically means that if it's a felony crime, you need to have subjective mens rea as part of it.
Okay, and now can we explain how he got convicted on 10 felony counts when only 2 witnesses appeared based on 1 incident of brandishing a firearm?
There are all kinds of issues, but technically there was video footage also admitted, and there was testimony that came in that a certain number of people witnessed it. And so the fact that so many of their witnesses did not even show was a factor that the trial court ignored in favor of the fact that there was testimony that more than 2 people witnessed it.
Okay, and I had one other question. I think, well, what is the status now? Have you filed?
No, the Oregon Supreme Court only turned it down last week, so we're on a 90-day clock to file the petition to the U.S. Supreme Court. So that'll happen this fall. I fought, even when it's an uphill battle to file in the U.S. Supreme Court, I always do, because you never know when your argument will, anytime you get a chance to get 9 Supreme Court justices to hear an important issue, even if they don't take the issue, you've planted the seed of the idea. And I've been doing this now for 15 plus years, taking cases up for that purpose. And I've seen it in cases they haven't taken of mine. I've seen the idea and the argument that we initiated and instigated show up in Supreme Court rulings. So it's always a good idea, but it's critical. I mean, if Strickland can be denied this defense, everybody can be denied this defense.
And Dapper Dave 527 says, can the DOJ join in the case by Strickland? What's my problem here? Can the DOJ join in on a case by like Strickland's when it is believed the Constitution is being abused by the state to fast track to Supreme Court?
They can. I don't anticipate that they will. So the Attorney General Barr has been very sporadic at what he's done on this accord. Now and then he steps in, but it's very rare for them to step in and second guess a state prosecution.
Okay, now one other thing. Tell me if I'm wrong. Well, actually, I had a question about this. Apparently, he was prevented under the judgment. Was he prevented from speaking on the issue and from reporting on subsequent issues? Effectively gagged? I mean, I didn't understand that, but that was what I understood.
Yeah, that was and the original scope of it was much broader. We did get it shrunk down. But yes, originally they were using it basically to prevent him from practicing journalism, preventing him from being part of the free press, preventing him from commenting on these individuals that were complicit in it, that of course would reappear in many respects. And so that was brought back, but it gives you an idea of what the mindset and what the mentality was. The prosecutor, the fact they even brought prosecution, the police even made an arrest, the kind of charges they brought, the way in which they lied about him for early on, the way in which they couldn't even get a fair jury pool and ended up with a bench trial, and the fact that the appellate courts and Supreme Court is turning a blind eye in Oregon to the gutting of self-defense and politicized cases it shows you where we're at, and it shows where the rest of the country is going to go if certain political actors prevail.